Hello. There are several questions in the community when it comes to the law, especially with the immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello, lovely people. Well, we're starting right again. My name is Oreku Frimpong, and good afternoon. Welcome to another edition of The Community and the Law, brought to you live on BWTV and sponsored by BWF Solicitors. Late, but not late. You need to start on time. But if you're not able to start on time and do it on time, is there any remedy? Are there things that you can do that will save your skin? We're going to look at the human face to the immigration application and appeal rule, and Lawyer Charles Asma is going to help us go through that. It's The Community and the Law and brought to you by BWF Solicitors. We counted down to Christmas, and I believe you are ready, as we are. So let's get into this together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, 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 and hello again. I, I I want to say thank you for joining us, and I would want to express our appreciation for you making time with us every Saturday afternoon as we bring you the community and the law. And I also want to get you to join us to say thank you to BWF Solicitors for helping us do this every Saturday afternoon. We're live on Facebook, we're live on YouTube at BWF Solicitors and at BWTV UK. My name is Ulrico Frimpong. Late, but not late. What does that mean? We're going to look at this in the context of immigration appeals and the rest of it. And this afternoon, as we normally do, our benefactors, BWF Solicitors, has made it possible for lawyer Charles Asma to be with us once again. Uncle Charles, good afternoon. Can you hear me?
Good afternoon.
Yes, yes, yes. Thank you very much for joining
Yes, I
us.
can.
How are you doing? It's a bit of a dull weather, but yes, the smile puts a lot of shine into it.
Yes, I agree, but we are making inroads. We are grateful to God.
Right. Yeah, you have a very nice way of putting things. Late but not late. Does I have to know in a brief summary, what are we going to look at?
Right. So we are looking at a specific context where when you thought that all is lost, but you later realize that, oh, after all, there is a glimpse of hope to rely on to bring to life that which you thought was dead. So it may be late, but then if you took your time, watched and listened and found out, you realize that ordinarily it is late, but further on it is not late. There is still hope.
Well, I believe if there was nothing you took away from the introduction of lawyer Charles Asma, it is that, listen, now it may be late, but look further, there's hope ahead. And that's what we're going to discuss this afternoon. So I want you to invite yourself one, invite other people, and also tell them to invite other people. Come join the community, and we learn and empower ourselves as far as the law is concerned. And that's going to be done by BWF Solicitors, our trusted partners when it comes to the law. I told you earlier on, we're live on Facebook and YouTube, and we are at BWF Solicitors and BWTV UK. So when you join us, like the page, make yourself known by putting in a comment in the comment section down below, and also invite people to come join us by sharing the page. If you are new here, welcome to the community. And what I would ask you to do is to click on the like button and on that notification bell so that when we put out content, you will be notified and you not. Once again, welcome. And let me see, maybe I've got people who have already joined me. Let me go onto the platform and pick up one or two who are here and shout out to you. Tilly Duma, lovely family, you say hello to us. Thank you very much, Tilly. Thank you for joining us. And I believe you're doing the needful by asking others to come join us. Yes, that's exactly what you're doing. Nanajimai, come, the class is on. And we believe Nanajimai will also spread his tentacles and invite other people to come join us. So when you join us, please let us know you are here. We are looking at what BWF Solicitors does for us, and we're so grateful that they do this every day. And people have taken time to express that. What I would ask you to do is when you have had the benefit of enjoying the services of BWF Solicitors, go to Google and give them the reviews, or visit their website www.bwfsolicitors.com and leave your reviews there. On the website, there are several assets and resources that you can use to your benefit. BWF Solicitors is on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. You can call them 0208 493 7340. 0208 493 7340, and you have the benefit of their services like K Ado has had and giving us this review. K Ado says, outstanding service from Mr. Bernard and BWF Solicitors. They guided me through every step of my settled status application with clarity and professionalism. Thanks to your support, my application was approved smoothly. Highly recommend them. So yes, come join us recommending BWF Solicitors as K Abdul is doing, and I believe you will also have some testimony of a sort to give. We're counting down to Christmas, and we're taking your reviews and all the other bits. And at the end of the year 2025, I want to say a big thank you to all of you. Now, later on in this program, you can have the chance, or you definitely have the chance, of calling us on 0208 493 7345. If you have any testimony to give, yes, you would be allowed to do that. If you have a question to put to Lawyer Charles Asma, you'll be allowed to do that as well. Now let's get into it. Earlier in the week, BWF Solicitors gave us something to chew on. That's what we call an nugget. And in this one, they are saying, in requiring evidence of biological relationship with a child, Home Office officials must not require applicants to provide DNA evidence. For example, in connection with amending a birth registration record, making an immigration application, or representation or nationality application, or an application for a British passport. Applicants can choose to volunteer DNA evidence either proactively or in response to an invitation to submit further evidence. Where applicants choose not to volunteer DNA evidence, no negative inferences can be drawn from this. Now, I quoted this from page 7 of DNA policy guidance published for Home Office staff on the 16th of March 2020. It sounds like it's clear, but let's look at some context of it. DNA evidence, what is it proving? Why is it not compulsory? Because we know that DNA evidence may, to a very high level, provide some accurate information. Lasma, why is it that it's not compulsory?
Right. So there are specific laws that govern determination of parentage of a child. And we're looking at the mother and the father of a said child. And the family law rules and specific case laws and also other statutes, especially Children Act of 1989 and other provisions. It tells, all put together will tell you that to identify who the mother of the child is, you look at the name of the mother on the birth certificate.
Okay.
To identify who the father of the child is, you look at the named father or the registered father of the child from the birth certificate. When in contention as to who the father is, where two adults, males, are fighting over paternity of the child, then we can resort to DNA. Especially where a court has made an order to determine the paternity of the child. And also there are specific provisions, paternity determination regulations. So you can see that once the birth certificate is there, whoever is named as the father of the child is the father of the child.
Mm.
We also look at section 50 subsection 9 of the Nationality Act of 1981, and also section 50 subsection 9 capital A of the same law. It says that where there is dispute, we look at who was married to the mother of the child at the date the child was born. So if at the date the child was born, the mother was not married to anybody, then the father is the one named on the birth certificate. If the mother was married to anybody and no divorce has taken place, then the father is the one married to that woman at the date of birth. And so you can see that DNA is a procedural matter. So you have to go through a process to have a DNA done.
Mhm.
That such process sometimes can be intrusive. And so it's not something that people can be forced to do. They can be appealed to, and if they wish, volunteer. So home office rules. And when we say home office, we are looking at those who are dealing with immigration visa applications and those who are dealing with passports are all under home office. So the passport office and other departments all of them come under home office. So if anybody is challenging who the father is, the prima facie document to rely on will be the birth certificate. Anything else is peripheral. Can we force people to undergo DNA? The rules are clear that staff of home office cannot force people or demand DNA evidence from people to prove who their parents are, whether father or mother. And so if the person wishes, they could volunteer DNA, but they cannot be forced to. So when in contention, the only evidence to rely on is the birth certificate, and that suffices.
Oh, okay. Right. That's quite clear. So, based on that, with your permission, let me see if I can tease some answers and some explanation from my viewers. Let's imagine Fatima had a baby, Said, with Mustafa. As Mustafa has an EUSS settled status, he applied for a British passport for Said under Section 1 of British Nationality Act of 1981. Okay. Now, the passport office wrote to him to demand that he carries out a DNA test to prove that he is the biological father of Said. Apparently, the Home Office didn't believe um, Mustafa. Mustafa says, well, I'm not too comfortable with the idea of DNA, and comes to you to seek legal advice. What would you think the advice would be? As the passport office has demanded DNA to prove he is the father of Said, he has no option. He must go ahead and give the DNA evidence. Would you tell Mustafa that DNA is the only way to prove that he is the father of Said? Therefore, if he does not provide it, his son's passport application will be rejected. Or we can just tell him, listen, don't worry about that. DNA is voluntary. Therefore, you can choose to provide it or not. Well, viewers, what do you think? Think about it. I'll come back to it at the tail end of the program and ask you what the correct and appropriate advice would be for Mustafa, who's had a baby with Fatima, and the baby called Said is in need of a passport. Anyway, we're going to see an application that was supposed to have been submitted within time, but wasn't done. Something that was supposed to have been done within time, but was not done, and we say you are late. Is that human face to it? particularly when it comes to immigration application and application appeal rules, so to speak. I know you are saying, yeah, there must be, well, of course, if it is late, it's late. But if it is late now, can we go forward and see why it could not be late? That's the point of discussion this afternoon, right after this.
Based in London, we are a dynamic award winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. It's still the community and the law and brought to you by BWF Solicitors. I mentioned earlier on that you can call them on 0208 493 7340. Those of you in Ghana, there's an office in Ghana where you can reach out to and make use of the services of BWF Solicitors. And the number is 055 589 5959. In all emergency situations, call 077 127 61884. 077 127 61884. BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we're looking at the topic late but not late. What are we talking about? Leasma, good afternoon once again.
Good afternoon, Rakuku.
Thank you very much. As I said, you have a very nice way of putting these topics, making it very relational and telling us how we can go about it in a very strategic, step-by-step way and all that. And today you've come up with late but not late. What are we looking at?
Thank you very much, Rakuku. So we are looking at appeals and immigration applications.
Mhm.
Appeals and immigration applications. So we cut both. And let me say very good afternoon to viewers and listeners for making time to meet for us to have this conversation together.
Mhm.
Now, under normal circumstance, you must not be late because lateness cannot be entertained because delay defeats equity under fairness principles or law and the law of equity. The delay defeats equity. So if you want to be treated fairly, you have to make sure that you do everything in time. Because if you are late, then you have no option. So the rules say that when you are late, that is it. There's nothing you can do. But then there might be reason for the lateness.
Mm-hmm.
There might be reason for the lateness. And therefore, if we paused and listened to the person who is late, we may realize that the person is late, but we cannot say that he's late or she's late on this occasion. And so, late, but not late all the time. What does it mean? So, under the immigration rules, before your visa expires, if you want to remain in the UK, you should have applied for extension or made another application for a visa alternative. Otherwise, once you leave it for it to expire, you have become an overstayer. An overstayer will have no place because they will be subjected to the strictness of the control of immigration processes. So, having this procedure in place that apply before the visa expires, what happens to people who may not be able to apply before the visa expired, but for good reasons? No reason may be good. However, if it is beyond your control,
Mm-hmm.
then that reason may be fair. And so we have to listen. What do we mean by beyond your control? Now, let's put it into practical context.
Okay.
You are supposed to go to work, report at a particular time, and leave at a particular time.
Mm-hmm.
What are some of the things that may make you not able to report at the time required? Let's put this into context. So let's have a what we call statutory activity. We are in the
So
classroom now.
there may be a traffic situation, traffic emergency. There might be a police activity that will prevent you from coming in, or exceptional circumstances, as you normally would put it. Somebody's falling sick all of a sudden within your community or within the home. These might be reasonable to give.
Right. So if it is you having to travel to the place,
Mhm.
if it's about traffic and all that, we'll look at the circumstance of the traffic. Could you have avoided it if you left earlier? But if it's a case of you left to avoid such traffic, however, due to accident that created health and safety situation,
Mhm.
there was no way under the circumstance, even the person with the best of will and intention could have continued the journey. Then it was out of your control. That is fair. Because if you had done it, that could have created more harm to other people within the community or passers-by or the police and other things. Your car breaks down all of a sudden.
Mhm.
What do? Either you go like that and cause further damage to yourself and people, or you wait. So, in terms of context, we can say that with these things, when they happen, we look at whether it is within the control of the person or not. You mentioned health. If you are not well, then that may not be your because if you are not well, what can you do? Somebody,
Mhm.
but if so, we're looking at particular context where you may not be well, but your wife or partner applied and they left you out. That one, you cannot rely purely on sickness because somebody else could have done it for you. So when they are looking at the control, there are a whole lot of other things that will play out in determining whether it is fair for this to be accepted. And so because of these factors, the laws were couched or the rules were couched to factor in these human challenges that come our way every time: sickness, bereavement, and other factors that we may not be able to control. So if you are sick and your visa runs out before you got better, and you are now going to make an application, can we say it was deliberate delay?
No, it wasn't, because
No.
you couldn't have done that in that circumstance.
Very good. That means you just have to prove it, isn't it?
That's right.
What about you had bereavement? At that time, you had two options: to forget about the person who is dead in the family and focus on your immigration status, because that is more important to you, or focus on the issue, which is death of the family member, and sacrifice your immigration matter and deal with that later, which is more important at the time.
Well, depending on how the person sees it.
I would say the family bereavement, if it touches the heart and the mind.
In the mind. Okay.
Bereavement that will touch the heart and the mind will cause us to focus more on dealing with that, including if we can even help to prevent. So that if your family member, be it external family member or nuclear family member, is deceased,
Mhm.
and the process leading up to that meant that you had to forget about everything and focus on that. That is fair. That is life. That's what normal human beings would do.
Would do in the cultural context as well.
In the cultural context and commonsensical context.
Okay.
Because even where the culture is not there, it will, and no, I mean, if you tell anybody that, oh, maybe this was happening to my family member, and so I became
I was in the
disorientated.
right frame of mind to do it.
Exactly. Would they tell you that, why didn't you forget about them and focus on your migration? Is that fair? Would that make sense?
Mhm.
No.
No.
So bereavement, depending on the role we play in that process, could be a reason why we might have overlooked or left out the application process. Again, sickness and some other factors. So what the law says is that when there is delay, you have 14 days within which to put in the application. What it means is that the law predicts or preempts such issues happening in life. And that is why in this topic, we said that late but not late. What is the human face of the law?
Mhm.
Because if the law doesn't have a human face, then the law will say that I don't really care. It is your responsibility to apply, isn't it? But because the law has a human face, then the rules were couched to accommodate such issues. So the first law we are going to look at to do with immigration applications under paragraph 39E of the immigration rules.
Okay.
The 39E says that if your visa expires and you apply within 14 days, caseworker must consider that and make an exception of the standard rule. So thank you, producer. So, producer, before this one, go to the first resource that talks about overstayers. Thank you, producer. So, this is version 12, and this came in on 19th of December 2025. Producer, just go down a bit for the date. Yes. Oh, 16th December 2025.
Mhm.
And if you go down for us, stay there. We are looking at applications. So, we are looking at considering good reasons beyond the control of the applicant. Rakweku, have you seen the part
That
and
should
the
be
paragraph?
that should be on page 7.
And also, so start from page 6, please.
Okay. So if we go up to page 6, for instance, it talks about I think one more page. Yes. So calculating the date, or probably from the top, yes. COVID extension concession and exceptional assurance.
We leave the COVID extension, but we just go. Which pages are we? Are we page 6?
Yeah, so this is 6, yeah.
Yes. So next level, please down. Yeah, from here. Migrant status following submission of an application. Yeah, here. Right.
Okay. So if we do a quick read of that, it says once an individual's permission has expired, they become an overstayer and no longer benefit from any conditions or condition that were attached to their previous permission, as set out in Section 3C Leave Guidance. Section 3C of the Immigration Act of 1971 does not apply to applications made after permission has expired. The submission or consideration of an application within the 14-day period set out in exceptions for overstayers in part suitability does not mean the migrant's previous permission and the conditions that were attached to that permission are either reinstated or extended.
Okay,
That,
let's pause here, Brakoku.
okay.
So this is where we'll come to this actually later. But the key thing we want to point out is that somebody will have 14 days 14 days within which to apply for extension or to vary the application or switch if the visa has expired 14 days. But that 14 days, you are in the grace period, aren't you?
Yes.
So once you enter the human phase of the law, that is the grace period, 14 days. At that time, you are not protected under Section 3C, which says that it's a shield and a sword, and so you are covered. So we are talking about where you have delayed in applying, but you have 14 days to still make the application. What if the 14 days is even more? You've gone past 14 days, it gets even worse. But you have 14 days, and within that 14 days, the caseworker must accept the application, considering the human phase of the rule, which says that if you are late for 14 days, you can still apply, provided you are applying within that 14 days grace period under paragraph 39E.
So does it
Now,
mean that if you go beyond the deadline and operate still within the 14 days, it does the application will be accepted, but you will not be protected by Section 3. Is that what it is saying?
very good. That is the rule.
Okay.
So when you enter the amnesty or the grace period, you are only given exemption to make an application for your visa to be renewed and so on and so forth. However, the protection you had before the visa expired cannot be following you or cannot still remain for you to use. If you are working, for example, and you are late to apply, your employer can say stay home until the grace period application is decided.
Okay.
That is something we have to point out. Whilst we are dealing with the human face of the law for lateness to apply, we also have to caution ourselves that the human face lateness to apply consideration does not extend to the protection under the law for those who apply before the visa expires.
Okay. And maybe for just a brief period, when we say Section 3C, what protection does it give anybody? Maybe briefly, so then we can put or situate that in this context.
Sure. So Section 3C of the Immigration Act of 1971 states that if you have a valid visa and you make an application before such valid visa expires, as long as a decision is not made to grant or to refuse, the right you had before the visa expired will remain intact. What right do you have? Right to work, right to rent, right to operate bank account, right to live your life without restriction. And the restrictions will only apply to the conditions you had under your leave. Then you are okay.
Okay. All right. At least then, those of you who may be confused about Section 3C, that's what it says. So instead of referring to all that long explanation, the lawyers help us to say Section 3C protection, then we know what it's about. Thank you very much, lawyer, for putting in that. So then we have looked at the 14 days to work within that. The applicant is putting the application and is operating within the grace period. What are the things to look for? Why would we have some confidence and comfortability within that 14 days?
Yeah, thank you. But let's look at the 6 core areas that an individual will have to consider whether they are finding themselves there or not. Producer, go to the one you showed earlier, the 6 core areas. So 6 specific areas under paragraph 39E. So when somebody is late, it might be due to one of the following, and these are the things that may happen. First one, you have a good reason to overstay.
Okay.
If we say good reason to overstay, overstaying means that because your application is late for week 1, for day 1, day 2, day 3, up to day 14, you have become an overstayer from that moment. I don't know if you get my point.
Yeah.
So if your visa expired yesterday, when did you become an overstayer?
From yesterday.
Yes, if it expired yesterday, from yesterday. If it expired today, then from today. Let's say your last date was yesterday. That means from today you are an overstayer. And says that even though you are an overstayer from today, you still can apply within 14 days, but there should be good reason.
Good reason.
So good reason overstay. Application within 14 days of leave expiry within circumstances beyond control. And that is the statutory activity we had, where we looked at medical emergencies, bereavement, and administrative delays.
Okay. And the administrative delays could come from the Home Office themselves.
The administrative delay will come from yourself. But question, oh, very good. What do you mean by administrative delay? For example, I'm submitting my application today, right? Even though I should have done it before the last day, which is today, nothing stops me from doing it today. If I'm doing it today and the Home Office system for submitting the application is shut, there are issues, or the system is under maintenance or whatever, and I'm not able to submit the application until 3 hours later or 3 days later, then my delay is caused by the administrative delay from the system, isn't it?
Okay, yeah.
That means I should have a screenshot to show that on this day and at this time, I couldn't submit because this is the error that came on the screen from the system.
Okay.
That is administrative delays.
Delay.
So, medical emergency from your side, bereavement from your side, of course, your family, administrative from the Home Office side. But you can't say that I forgot. You can't say that I didn't have money. You can't say that I couldn't do it. That will not be administrative delay or reason. Then point 2. What's point 2, Brakoku?
Point 2 says post-refusal applications. And this is explained as following refusal of previous in-time application. New application within 14 days of decision notification.
Good. Let's take example here. You make application, you are extending your visa for 2.5. You cannot afford the fee, so you apply for fee waiver.
Okay.
Fee waiver was not successful because they found out that your bank statement has a lot of ins and outs and you couldn't justify. And so they rejected the fee waiver. But by the time they rejected the fee waiver, your visa has already expired and you were protected by the fee waiver.
Okay.
Now, fee waiver will give you 10 days, which is 10 working days plus 2 weekends, making 14 days, isn't
14
it?
days, okay.
To put in your application. Otherwise, your visa will now be completely out. This is where we say that you are making an application following rejection or refusal of in-time application within 14 days.
Okay.
So if the fee waiver has ended and they didn't give you the code and you have to pay for it, you have 10 days, 10 working days or 14 calendar days to make an application for which you requested the fee waiver so that your protection will continue.
Okay.
But if they give you the 14 days or 10 days to make the application, pay for it, and you say, I can't still pay for it, I'm going to do another fee waiver. And then the time runs out while the second fee waiver is pending. Then you are completely late
Okay.
because the chain is broken and it is more than 14 days.
Because they
That
gave
is
you a chance previously and you couldn't use it properly.
very good. Another example is where you make an application, for example, for skilled worker visa, and you made the application in time. You made priority application, and you were refused. By the time you were refused, you have about 1 day left. 1 day left.
Mhm.
Then within that 1 day, you had another opportunity for another application to be made. Maybe your child has been born to you and the child mother is British or father is British. So you are applying as a parent under Appendix FM. But within that time, your visa has now expired, but not up to 14 days. Then you can apply. Because the first one has been refused. It was in time. You are making another application under another category. However, the first one expired. You still have about 14 days to go after the expiration. If you make the application, you are within 39E rule because you are making a new application within 14 days following refusal of an in-time application.
Okay.
So this is where somebody will say, "Oh, lawyer, my visa has been refused, but I've gotten another opportunity. My visa actually has now expired. Can I apply?" If it is within 14 days after it actually expired, yes, they can apply again under 39E. And the reason is that they made an in-time application and was refused. By the time the person was refused, the visa has expired, but it is not up to 14 days, and they are making another application
Okay.
within the window of grace or opportunity. Then we go to section 3C extension.
That's an interesting and a very let me put an interesting one. What I'm saying is interesting is that we said that when you operate within the 14 days, the cover and protection given by Section 3C ends there. But now they are saying they can extend it. Under what circumstance?
So we are looking at point 3 and point 2.
Mm-hmm.
There's something called difference. How different is 2 and 3? 3 says that 3C extension application within 14 days of 3C expiration following concluded appeals or administrative what reviews. So here we are looking at appeals and administrative reviews, isn't it?
Mm-hmm.
Now we know that when you make an in-time application, you are protected under the law, so that you can work, you can do everything that you used to do. And once the visa is refused, you have two options: administrative review or appeal, depending on which one is given. Once you make an administrative review, it can take forever or it can take some time. Appeal can take 1 year. 3.3 says that where you have made an application within 14 days of 3C leave expiry, following what? Administrative review or appeal. At the time your appeal is in process or administrative review is in process, if your original visa that was refused was made in time, that whole period of administrative review pending and or court appeal pending, you are protected under 3C.
Okay.
However, you get to a point where you say that I'm now going to make an application for any other under any other category. And here it says following conclusion of the appeal. So your appeal decision came today. Once your appeal decision comes, you have 14 days to appeal again if you are within the UK. So we are talking about people in the UK actually.
Mm-hmm.
So you have 14 days to appeal again. Or if it's administrative review, you have time to move to the next stage. They are saying that if whilst you have 14 days following the appeal conclusion, you make an application for any other visa consideration, even though the 3C extension has now expired up to the point of appeal process. You now have your 14 days following the appeal to use it as good reason for making a new application out of time.
Okay.
So the first and the second and the third, the first one, you make application, it is refused, and you are making another application. The third one, you make application in time, it is refused, and you go to court to appeal, or you seek administrative review. And once the administrative review or court appeal is concluded, whether they rejected the review application or they dismissed the court appeal, if you put in another application within 14 days, then you can rely on the 3E rule to say that the reason why I have delayed for 14 days or my visa has completely expired is that I was waiting for the appeal or I was waiting for my administrative review.
Okay.
So that's the difference between 2 and 3.
And
Now
then
let's
does
go.
it have any linkage to 4, for instance?
Now
Appeal
let's
or
go.
review conclusion, which says applications following administrative review or appeal determination within specified timeframes. Do they link up like that?
So it says the applications following administrative review or appeal determination within specified time frames. So there are instances where court or home office will give you time that you have maybe a certain time period within which to do something. Once they have given you time period within which to do something, you have concession within the rules why you were late because they gave it to you.
Mm-hmm.
So that is the point 4. Then we go to the COVID. We know that the COVID concession came in 2020 for people who had overstayed and couldn't apply in time. They also have good reason, and the good reason is that COVID restricted them from making an application. But we know that we are talking about this in 2025,
2025.
and therefore this may not be practically useful today because 5 years on from COVID-19 concessions, not many people will be able to rely on that within 14 days.
Okay.
And so, even though we are mentioning it, it could be somebody who made such application and the person went to court and the court process has delayed and the matter is being heard in 2025 and the court wants to know whether the application was made within 14 days window in 2020. Yes, this will still be valid because the court process has delayed up to today. But it's not common though. Then we go to Ukraine. Ukraine extension is 90 days protection. And so for such people, they will have a window of time within which so if they had delay as a result of issues with Russia-Ukraine war and so on and so forth, then the concession will play out. And that would be good reason for not applying in time. But for most of us on this forum or on this show today, we are actually looking at point 1, point 2, and point 3. COVID will not be relevant to most of us, and Ukraine war will not be relevant to most of us.
Okay, so we have looked at what situation that would get us really falling into these categories where we could apply and also get some extension and the grace thereof. We will be moving to the next step of the discussion, but before then, I want to say thank you to BWF Solicitors for their time, for their efforts and resource, and of course, allowing lawyer Charles Asma to give us this very, very important resource, and we empower ourselves. BWF Solicitors is located on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 734 00208 493 7340. Or you can visit the social media platforms all at BWF Solicitors. Let's take their message, and when we come back, we continue with the discussion. Is the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
BWF Solicitors, thank you so very much for helping us do this. So those of you who have joined us, yes, as I said, keep your comments in the comment section below, or you can send a text to 073 Lawyer Charles Asma from BWF Solicitors is with us, and we're looking at late but not late. We're talking about the human face of immigration application and appeal rules. And we've looked at certain scenarios that the exemptions 39E would give us. Lawyer Asma has also explained what the protection of Section 3C is. And we're putting that two together and moving on to the various categories of applications we make, the EU application, the British Nationality Bill, um, the issue of fee waivers, and all the rest of it. Now we're going to some specific details. Asma, does this cover every application and every category of it?
Yes, so every application will have this. However, there is a variation to EU applications,
Okay.
because with EU applications, your lateness to apply should be supported by what we call reasonable grounds under Appendix EU provisions.
Mhm.
And so somebody who was meant to apply by June of 2021 is making an application in 2025. That is more than 14 days, isn't it?
Yeah.
So much as everybody who is making an extension application should apply within the 14 days, so that one covers everybody. When it comes to EU applications, even though it is over, if you have good reason why you are still making a EU application, the law says that, or the rule says that, quote the reason, and the caseworker may be able to consider. So for EU first-time applications,
Mhm.
for EU extension applications, they follow the same principle or process, 39E. But for EU first-time applications, these are the conditions the rules allow. Producer, do you have the resource for EU late applications? Thank you. So this is September 2023 guidance.
Okay.
Rakuku, what's the caption?
It says reasonable grounds for failing to meet the deadline for returning to the UK.
Yeah, so for example, somebody who has traveled outside the UK, returning to the UK, they couldn't make the deadline, or somebody who is applying under EU concessions. At the time, they said that by June 2021, and it went to 2023 August. We are in 2025. Can I still make EU application? The answer is yes. But why have you not made the application long time ago, up until 2025? After the process was completed or is no more, you should have a good reason. So scroll down, please, for us. Let's look at specific conditions that may be there. Examples. Good. All
Okay.
right.
So
So,
this one
brother,
says examples of reasonable grounds for failing to meet the deadline for returning to the UK. The preamble is giving go to employment or study, which has the detail as thus: where the qualifying British citizen or a relevant family member had an employment contract or was enrolled in a formal course of study in the EEA host country, which continued to run beyond the applicable deadline and which terminated, including if it was terminated by them within the period of 6 months following that deadline. That will constitute reasonable grounds for the applicant to have missed the deadline for returning to the UK from the EEA host country with a qualifying British citizen.
so here we are looking at people who are returning to the UK. What about people who are already in the UK and they want to make an application from, let's say, student to EU, or from skilled worker to EU, and so on and so forth, switching category from one to EU? What could be the reason why they have not made the application in time? So back to the original conversation we had for failing to submit your application within 14 days. The first one is bereavement. The second one is medical conditions. But sometimes there could be weird reasons. For example, your EU national who is supposed to sponsor your application is at sea.
Mhm.
At sea. And now when people go to sea, they sometimes return after 1 year or 2 years and so on and so forth. And if you are waiting for them to sponsor your application, you have to wait, right?
Mhm.
In this case, that reason could be a reasonable grounds for bringing your application at this time since 2023, when they said that EU applications could be made up until 2023 August.
Okay.
Again, we talked about the EU national who is supposed to sponsor application is seriously unwell
Okay.
and they cannot bring themselves together to focus on your application. Then that could also be reason. But that sickness, what it means is that should have lasted for how many years? 2 years, right?
Mm.
It's possible that somebody will have such prolonged illness and
Okay.
treatment. And so if that is the case and you have your evidence, that would be reasonable grounds. Again, the family member is supposed to sponsor your application when you were a student. But because of your maybe assertiveness and so on and so forth, the person is your mother, your grandparent, or whatever. They are saying that you are supposed to follow what they want you to follow. And you also believe that you are able to also make certain decisions. So why don't they give you some flexibility? And that friction has created contention between you and your family member, be it your mom, your dad, your stepmom, your stepdad, or your grandparent.
Mhm.
After resolving the matter, it's taking a long time. That could be a reasonable excuse why you are late in
But
bringing
now,
your
in
EU.
this case, how do you evidence that kind of friction?
Yes. So you take a common sense approach because not every issue that has to be that sometimes the story can speak for itself. But if the story is remote from what is objectively acceptable, then you have to justify with evidence. Let me give you an example. There is an old lady whose application I handled. We're making the application to extend the visa. We put in the fee waiver, it came. By the time the fee waiver came for us to continue the main application, I couldn't find her. She was not open to communication, emails, letters, and all these things were not going through. She was, yeah, at the moment she's about 80. At the time she was about 79. So I even got scared that, hey, is she all right? Has she died? What's going on? After 3 months later, I managed to reach her. Then I had to put in, because I needed information for her to approve certain things. They will put in the application. So I had to write a cover letter explaining the delay, the fact that I struggled to reach her, the fact that her age and all that, and the age and illness and such that even difficult for her to handle her own mobile phone to pick calls, to receive calls. And she lives alone. There's nobody around. And it is out of sheer luck that we eventually got hold of her. However, even though it is beyond paragraph 39E 14 days, it will be unreasonable for them not to accept the reason which we have narrated. Consider the age, consider the feebleness and frailty, and consider the circumstance of this applicant, and understand that under the circumstance, it is possible that she was genuinely not reachable.
Okay.
And the eventually, the decision came. The decision came about what, 2 weeks ago? Yeah,
Okay.
they granted.
Right. Well, evidently that's what you get from BWF solicitors because they're very meticulous, they pay attention to detail, they examine your case so very well, and they put in the right applications so you can succeed. Well, we've looked at these evidences, the EU situation. Of course, the bottom line is evidence is the name of the game. If you're delayed for any reason, and some of them have been outlined medical, bereavement, and all the rest of it. We're talking about the EU situation where there have been some variations and the rest of it. You can make an application within the grace period and it will be looked at because the rule and the law says that they should look at that within those circumstances as lawyer has explained. Yes, we're going to go on, moving on with the discussion. But I want to just remind you that you can send in your comments and your questions, any question on this topic and or any other legal issue, especially when it comes to immigration matters. You can put them in the comment section down below at BWF Solicit, both on Facebook and YouTube, and at BWTV, both on Facebook and YouTube. Well, let me give you a sneak preview of what our social media handles are, and we'll come back with Lawyer Asma to continue with it. Yes, we are back, and thank you for sticking around. The numbers, as I said, are active. You can text in 07399208 or leave the comments in the comment section either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Last one, yes, we have looked at the variation. We have looked at the exemptions. What next?
Yes, so now so we've looked at the human face of the application rules, UK immigration application rules for late but not late, in that even when you think you are late, you can still make an application because the law has a human face. We are
Mm-hmm.
looking at this time appeal. What if you are late to make an appeal or administrative review application?
Mm-hmm.
Does it also follow late but not late? The answer is yes.
Okay.
So we look at, for example, First Year Tribunal Procedure Rules 2014. And the First Year Tribunal Rules Procedure Rules 2014 is the one the court will follow to accept an appeal against a refusal decision. Under Rule 19, 2 and 3, Rule 19.2 says that if you are making an application to appeal a refusal decision in court, you have to bring the application for appeal within 14 days from the date of the decision if you are in the UK. And 19.3 actually says that if you are outside the UK, you have 28 days. That means if you don't do it within 14 days, that is appeal, or 28 days if you're outside the UK, then you cannot bring your appeal to court. However, the human face here is that if you want to bring the appeal to court after the 14 and the 28 days, depending on jurisdiction, you can, but you have to add explanation, what we call extension of time request. Under extension of time request, it follows Civil Procedure Rules, CPR 3.9. So CPR 3.9 will tell you that if you are making an application to court and you are out of time, you have to give respect to court and give reason why you are late.
Mm-hmm.
Again, it follows the case of Denton. There's a case law called Denton. Denton says that in bringing a late request for consideration by the court, you have to check whether the issue is serious. And of course, late is serious, isn't it?
Yeah.
And two, whether the seriousness can be pardoned. And three, whether you can be considered under the circumstances or in all circumstances. And so the court will listen to your argument and say that even though you are late for 3 months, you are late for 14 days, you are late for even 1 year, under the circumstance, you have to be pardoned and given time to appeal.
Mm-hmm.
Again, there's a case called um, Onowu. Onowu made application to court. It was out of time, but gave reasons under the circumstance why the court, why the appeal was not submitted within 14 days from the UK. The court accepted the explanation and granted extension of time. Again, if you want to make an application for judicial review under Upper Tribunal Procedure Rules 2008, it says that you have 90 days to bring judicial review. But if you are late to bring the judicial review beyond 90 days, again, you must have a reason why you are late, and the court will assess the reason. So whether it is appeal, it is administrative review, it's judicial review, or it's immigration application for visa, they follow the same human face principle that when you are late, there could be amnesty provided you have good reason why you are late.
Right. So, good reason. You are late. You put in the application. The 39E will protect you if you have enough evidence to show that you were late one way or the other. There's one very nice and interesting situation. The response they may have given me or some material went into my junk email. Is that a good reason?
Response from, you mean the for appeals?
Yes,
Okay, junk email. Whose junk email?
mine.
So your an email you administer.
Yeah, I have control over it. It's my email. I
Yes.
access it all the time.
Whose
But it went into
responsibility
my
it is
junk
to
and I
check?
couldn't see it.
Whose responsibility it is to check everywhere?
Mine?
How did you know that? How did you know that something called junk mail exists?
It's part of my email configuration, really.
So you know that it is there, and sometimes you have to go there.
Yes.
Why didn't you choose to go there every day to find it early?
Like junk mail are junk things that I do not need to.
So you see, these are the questions that the court clerk will be, or the judge will be teasing out.
Mhm.
You managed to get it at the junk mail junction, but what made you go there to find it there? Accidentally? Do you usually go there, or this is the first time you've been there?
Accidentally because I don't go there. And junk
Right.
mail are mails that I don't really need all the time and may not even be relevant to my intentions. So, for instance, marketing materials and things that I do not need to look at.
On that basis, we're looking at how sophisticated you are, your level of your IT skills, or your appreciation of IT usage and all that,
Mhm.
and put all this together and conclude that somebody with less appreciation of IT, emails, and blah, 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 it's possible that they don't even believe that such one exists, and they might have chanced upon it because they don't usually go there.
Okay.
But if you are somebody who is IT savvy, that's your job, then you cannot tell anybody that you didn't know that spam and junk mails are part of your email configuration.
Okay.
So again, depends on who and whether it will make sense to an objective bystander that they are not supposed to be checking their junk mails as part of their email configuration.
Could that be the reason why these days, when you having a correspondence from the Home Office, they tell you you can check your spam as well because it may have gotten there?
Well, in this case, they are even putting you on notice that check your spam, even if you didn't know, so that you don't use it as excuse that I didn't find it.
Okay.
And now you know what they also do. When they send you the decision,
Mhm.
they will, read receipt.
Okay.
So they set it up such that they can have the read receipt.
So
So
when
if
you
you
read
claim
it,
that you never received
you
it,
notify them that this email has been read.
exactly. So if they really want to, they will have a way to know that, hang on, you got it at this day, at this time.
Okay.
But whilst we are here, if the application was made for you by a friend or a helper who used his or her email and you can't find them,
Mhm.
by the time you found them, it was already late, and you realize that you've been refused for about 6 months, that would be a fair reason to seek extension to appeal.
Mhm.
Or your lawyer did it for you, and for whatever reason, you can't find, you couldn't trace, and whatever, that will also be a good reason. So the good reason will depend on the context.
Okay. And yes, context. So then we can say that they are looked at on individual basis because each case is different.
I agree with you.
Okay. All right. Well, do they normally become quite hard on people and probe every reason so much so deep that you do not want to really take advantage of these concessions that they have given lawyer?
So there's something called the overriding objective of the
Mhm.
court and the justice system,
Right.
and also another part called case management powers. So when we look at the overriding objective of appeals, it is to make it fair for both parties. And so, if, for example, my only remedy is to appeal, because if I don't appeal, I am already 18 years. I'm no longer a child, and so I cannot make even a child application. Then appeal becomes my only remedy, isn't it?
Mhm.
And so the overriding objective may be that for there to be fairness, we have to make an exception of the lateness and consider the reason so that this person who has already turned 18, but before the application was made was under 18, can seek redress or remedy under the law. And for that matter, the court will invoke its case management powers under the rules to say that even though you are late, we have considered your lateness reasons and accepted the appeal to go through.
07399208468, our text number. You can send your WhatsApp messages to that as well, or you can leave them in the comment section down below at BWF Solicitors, both on Facebook and YouTube. So now I'll open it up, and the telephone lines, of course, are active now. 0208-493-7345. 0208-493-7345. You can call in and ask your question. Leah Asma is here. And remember, we're doing this by courtesy of BWF Solicitors. We have a few of them on the platform already, so we'll be picking that. But remember, I asked you to look at my situation or scenario where I said to you that per the nugget, people at the Home Office really do not have to ask people to provide DNA evidence. And I had the situation where Fatima had a baby called Saeed, had a baby with Mustafa. Mustafa has an EUSS settled status. And based on that, he applied for a British passport for the son Saeed under Section 1 of British Nationality Act of 1981. The passport office, however, wrote to him to demand that he carried out a DNA test to prove that he is the biological father of Saeed. What advice would you give Saeed when he approaches for any? As the passport office has demanded that, are you going to tell him that he should go and do the DNA test to prove that he is the father of Saeed? Are you going to say that DNA is the only way to prove that he is the father of Saeed? Therefore, if he does not provide it, his son's passport application will be rejected? Or you would say that DNA is voluntary, therefore he can choose to provide it or not. Think about that. But let's pick up your comments and get Lawyer Asma to help us answer them. Comments, questions, and suggestions, so to speak. My brother is here in London, and he went to Ghana last month to get married. He wants to apply for spousal visa for his wife. The only photos they had are those taken at the KMA, that is the Kumasi Metropolitan Authority office, when they were signing the certificate. Are those photos enough to show to the Home Office that they are in a genuine relationship, or he needs to show different locations where they've taken photos, which will prove that they were together whilst they were there? What would be the best, Lawyer?
Right. So when we live lives together with family members, photos serve as proof of our lives because they're only giving us something to remember. But photos don't really mean that we have lived lives.
Okay.
And so not everybody has photos. And so you can't tell me that because I don't have photos of my marriage, I haven't married or been married. What about the registration confirming the marriage? Is that not evidence enough? And so photos are peripheral. If you have it, they only prove that something happened. But if nothing happened, then court wouldn't have registered the marriage for you. So normally we have the photo to show, just to add to it, but it's just an add-on. So my brother, if your brother indeed married and your brother has the marriage certificate, be it ordinance or customary marriage registration under the Ghanaian Marriage Act of 1985, then that is enough.
Okay. Well, Perpetual, thank you very much for that. Let me also say Charles Emery is watching with us. We have Tricia also watching with us. Charles is asking, when can you follow up on a review or an administrative review after waiting for over 7 months. That's
Charles,
quite long.
I would say that 7 months is lower than somebody who has been waiting for 2 years.
Okay.
Because somebody has been waiting for 2 years. We've done PAPs and PAPs and PAPs. If there's any other word beyond PAP, I'm sure we'd have tried it, but there's nothing again to do. So we are waiting. And they will write you to you. Now, all the administrative reviews I've done, they will email me and say that we know you have been waiting for a long time. This is just to let you know that we still have the application. The reason why it's not decided is that we have a backlog. And so a decision will be made. What can you do? You just wait, Charles.
Wait and patience is a virtue. So, yeah, have it. It will come. Definitely, don't give up. Yes, keep them coming through 0739920848, or keep them in the comment section down below, either on Facebook or YouTube. Newcastle says, I would like to ask, I'm on a 10-year route and I would like to switch to a 5-year route. I'd like to find out if parents of British children are part of those the Home Office will put on the 10-year route or can still make the application to switch from 10 to 5 years. Laura.
So I would like to, I'm a 10-year route and like to switch to 5. Find out if parents or relatives are part of those home office would put. Okay. I mean, if you are switching to 5, fine. But if you are switching to 5, just make sure that it is necessary to do so that you don't waste your time and money. Because if you're already on the 10-year route and spent 5 years, switching to 5-year route will mean you still have to wait for another 5 years. Because 5 years, you are starting all over again.
Mhm.
So if you are going to start all over again for 5 years, having already done 5 years, then that's 10 years. Why do you waste time and money? Continue like that. Now, in terms of those who are parents and applied based on their children and all that, they said that those who applied based on British children and British spouses will not be affected by the proposal once it is converted to law.
Mhm.
However, if somebody was or has been receiving benefit, then the person may be affected once the proposals are made into law. So I wish you added whether you are on benefit or not. If you're on benefit, then you'll be affected. If not, I don't really think, but we are waiting for the proposal to come through. So once the proposal comes out, please come back and we'll be able to answer. And now your question will be, now that the proposal is out, what is my fate? And we'll be able to give you certain response.
And that even reminds me that we were asking people to log on to the uh, discussion and let your opinions known so that we can have a lot of people contributing to it. And if there's anything we, as people that these things will affect, are not in favor of, we will have the power to do that. So get onto that consultation page and get something in there to add to the number. Danny Seawood says, Lord Charles, thanks so much for your advice. Danny, thank you also for sticking around and listening to us on the program, The Community of the Law, and also uh, making sure that you are glued to BWF solicitors. I entered the UK, Danny says, with my wife in May 2022. A year later, we had a son who has since left here without any travels abroad. I need to extend our visa to because I have not completed my studies. Our initial visa ended, in November 2025 and got extended to September 2026. However, my son's application was refused on the grounds of inadequate financial requirements. Honestly, I thought because he had lived here for over 2 years, he didn't need to attach a bank statement, and so we didn't build one. Now he's been refused and given 14 days to reapply or get administrative review. Lawyer, what do I do?
Right. So this person is a student or PSW. I entered the UK with my wife in May. We had a son. I don't know what sort of visa they entered with, I needed to extend our visa to all this. Why he hasn't mentioned what visa category, right? Studies. I've seen studies. I had not completed my studies. I need to extend our visa because I had not completed my studies. Anyway, we don't know what sort of visa this person has. But Danny or Dennis, what we'll tell you is that if you and the child's mother have lived to remain in the UK and the child's visa has been refused, if you are going on admin review, you can add the evidence of the maintenance that you now meet. Even though the administrative review, you are going to challenge the refusal, ideally, they can say that, well, at the time you applied, it didn't meet the requirements for maintenance. That's why we refused it. But when you are making the admin review, you tell them that because there's what we call other reason. Other reason would be that they didn't apply the evidential flexibility principle before making the decision to refuse the child. If they did, you would have been able to provide them with the evidence of the maintenance, which is the bank statement. And because they didn't do it, they concluded that you don't have it and they refused the child. When you are applying admin review, you select other reason. If you select other reason, you explain that the caseworker did not apply the evidential flexibility rule to request evidence of maintenance proof before making the decision, and therefore you want the matter reviewed. Then you, as part of your evidence, you have to add I think it's 28 days continuous for the period up to the time of application. Add all that evidence that you have enough money for yourself, your wife, and your child so that you don't become a burden on the state, and make a good argument that even though they may be right, for the fact that they didn't come for clarification before making a decision, made the decision unfair and unreasonable. And on that basis, you have the evidence they could have obtained if they came back. And so they have to reconsider in the interest of the child. You can do that, or you can make another application if both of you have visas to say that your child has no visa, you make an application, both of you have leave to remain. And on that basis, they have to consider your child. So you have two options, either to reapply or to seek admin review. Consider the cost, consider the time, and put in admin review or a new application. If I was in your situation, to be fair, I would seek admin review. However, that may take longer. And for that reason, you may wish to put in a new application and argue strongly that even if the child is out of time, there's a good reason, because the conversation we had today says that if somebody had leave and was protected under Section 3C, and the person's visa application has been refused, and before going for admin review or court has decided to make a new application within 14 days, then the person is covered under the rules. And so you can make a new one for the child.
Cogent advice coming from BWF solicitors with a resource person, lawyer Charles Asma. This afternoon, we've discussed, late but not late, the human phase of immigration appeal and applications. Kwekwan Kuma comes in with a friend did an application for a family member who knew the friend is married, but the friend who did the application used his wife in place of his friend's wife. Know what should the family member do?
Okay. So now what should the
the
family
UK.
member do?
Can I leave and come back to continue my station? What should I do? I think that's a different question altogether, maybe.
So the first question is where somebody makes an application and instead of using the applicant's spouse name, they use the helper's spouse name, right?
They love their wife too much.
They love their wives too much. They forgot that they are working on somebody's application. Imagine a lawyer doing that. Anyway, there's no justification, my brother. This you need a proper advice, not few minutes advice on social media. You need one-to-one so that we can get the context properly. So I will not be able to advise on what to do unless I have had full benefit of the fact. I have to probe further. so that I can work out what is best under the rules for you? That's the first question. Now, the second question: 3 years in the UK, can I leave and come back to continue my years of staying? What, 3 years in the UK? Do you still have a visa? Kwekwa Nkrumah? Yes, you've been here 3 years. When does your visa expire? If you still have a visa in the UK and it's going to expire in the next year or so, then you can go travel and come back. Yes, you can go on holiday. But if the visa has already expired, then don't expect to come back if you leave. Or the visa has expired and you are waiting for extension decision, then don't travel, because the application will not be decided once you leave the UK. So you can see that we don't have enough information to answer your question. Once again, you have to come back on this one.
Go come back on this one, and I know you have the appropriate and accurate answer to this one. Dennis comes in and says, additionally, I've now started building my statement, and the 28-day period will go beyond 14 days that I've been giving. In that case, what do I do? Am I protected by 3C or 39E?
What it means is that the caseworker is right. That even if they had come for evidential flexibility concession for him, he couldn't have been able to provide the evidence. You agree with me, Brakweko?
Yeah.
Well, he says he's now building his
Now
statement.
started building the statement.
Yeah, so it's true that he wasn't there. And so the decision to refuse is fair, isn't it?
Yeah, obviously, because you didn't
He
have
didn't
it.
even have it. So it's not a case of why didn't they come back? Even if they came, you couldn't have provided. And so what do I do, my brother? Listen, whether you do it now or not, you need the evidence. And since the evidence is not ready, don't rush to do anything. Build the evidence, and after that, you put in application for them to consider. Okay? It's for the child. And if both of you have visas, that's why I kept asking, do you and the child's mother have visas in the UK? If you do, then you to go under favorable discretion principles, where the caseworker will be requested to consider the best interest of the child. So, my brother, this is one of the cases where you go beyond Facebook advice and seek one-to-one. If you care, please, let's hear from you.
BWF Solicitors is on the fourth floor of the Honor House, 214 to 218 Tottenham High Road, Seven Sisters. You can contact them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Numbers on the screen: 0208 493 7340. In emergency situation: 077 127 61884. Or if you want to reach out to Lawyer Charles Asma himself, you can call him on 07947 636037. Sometimes these short answers may not help you, may have to sit with you and probe further so they can give you proper advice tailored to your situation. We're live on BW TV, and we're taking your comments, your questions, and concerns. Akuya has this one where what form should I use for naturalization for my children under 18? And how much will I pay?
So it depends on the basis of the registration of the child. Ekuya, are you registering your child because you are using your own indefinite or your own citizenship to register the child, because now you have gotten your indefinite and your child is still under 18? Or you are registering your child because your child is 10 years and you want to apply to register the child? If you are registering the child because you have indefinite and you are registering your child under section 1.3 of the British Nationality Act, then you have to use form MN1. Form MN1. If you are registering the child because the child is 10 years in the UK, the child was born in the UK, and the child has continuously lived in the UK, then you are applying for citizenship for the child based on the child's private life. That you use Form T. So these are the circumstances. If the child is applying from abroad based on other circumstances, you use Form UKF. So there are different forms. And so I'm only generalizing it, giving you different assumptions. And if any of the assumptions apply to your case, then you know the form to use. If you want to come back again, please do get in touch and let's help you so that you can get the registration done for your child one touch.
Okay. 0208-493-7345, 07399-208-468 for text, WhatsApp, audio notes, and the rest of it. Or you can keep them coming through our comment section down below, either on Facebook or YouTube. The next one is from Danny C. Woods. If someone comes with a charity visa and gives birth, can the person switch to a spousal visa? Lawyer.
So, Danny, I want to believe that somebody who has a baby, the baby's father is either, well, we don't know whether that person is man or woman. So let's say the parent, one of the parent, the parent is British or has indefinite. If one of the parent is British or has indefinite, then the child will be British under Section 1 of the British Nationality Act 1981. If the child is British, then the child is a qualifying child under Section 117D. If the child is a qualifying child, then the other parent who came as a charity visa holder can switch to 2.5 as a parent of a qualifying child. So that is how the law will apply in the person's case.
Danny, thank you very much. We'll take one more and take a break and come back to our quiz question. Grace Asabia Asari. What if you have certificate of sponsorship already in the country and you have relatives on your visa, but they are not here yet? Can you bring them in?
Okay. Now, let me take the opportunity to clarify something for everybody and specifically for Grace. I said everybody because what Grace has said applies to many people.
Mhm.
When people make application and they ask you, do you have children who depend on you? And you say yes, and you mention their name, it doesn't give them automatic right for visa when they are ready to apply for visa.
Okay.
So people will say, lawyer, me my application me to wait. When I was applying, I added my children's names to my application, and so I want to bring them. You are not bringing them because you mentioned their names on your application. You mentioned their names because when they asked you, do you have children? You had to say yes and give the names.
Mhm.
So if you are ready to apply for them, you have to prove that they qualify to apply. Having children doesn't mean they qualify to apply. So if you have certificate of sponsorship, depending on the type of certificate of sponsorship based on occupation code, and depending on when it was issued to you, you can bring your dependent or not, including those children whose names you have already mentioned, not added, mentioned in your application. So, Grace, I don't know whether your children qualify or not. If they do, you can bring them. If they don't, then you cannot bring them. Whether they do or not depend on further conversations we must have. So, Grace, please get in touch. Let's discuss whether the children qualify under such COS provisions that you hold and when you can apply for them to join you and the requirement you will need.
It is always the best for a layman to give their job for an artisan to do for them. You and I are not lawyers, but we have the very competent ones like BWF solicitors who would be in our corner to fight for us. I will give this exception. What's the word? Anyway, Yasari has come in and Yas says on spouse visa extension, how long do you have to wait after you submit your application? Well, I know lawyer will tell you, they will tell you there's a lot of backlog. So he may delay. Am I right?
All right. I was going to ask him, how long have they been waiting for? But I mean, for spousal applications, the good news is that they don't delay as long as the standard applications or the non-spousal applications. And so I will use the experience in terms of the ones I have put in. The ones I have put in, some of them will come within 1 week, some within 2 weeks, some 1 month. And therefore, my conclusion for spousal applications is that they don't delay as long as parent and other applications. And especially if the person made a priority application, that one within a day or two, they get decision. So, yeah, sorry. I don't know whether you are now going to make the application. If you are making the application as a spouse, please, if you don't have money for priority, put it in. If you want us to do it for you, come to us. We'll definitely assist you so that we will handle your trouble and you will enjoy your peace. But the most important thing is that how long it will take for spousal applications, they come quicker than parent applications and other non-spousal applications.
Well, I gave you the nugget that BWF solicitors supported us with and asked us to look at, and it was about DNA policy guidance. This was published for Home Office staff on the 16th of March 2020. And this says that in requiring evidence of biological relationship with a child, Home Office officials must not require applicants to provide DNA evidence. For example, in connection with amending a birth registration record, making an immigration application or representation, or nationality application, or an application for a British passport. Applicants can choose to volunteer DNA evidence either proactively or in response to an invitation to submit further evidence. Where applicants choose not to volunteer DNA evidence, no negative inferences can be drawn from this. So based on that, I had a scenario with my lady friend who had a baby called Said with Mustafa. As Mustafa has an EU SS settled status, he applied for a British passport for Said under Section 1 of British Nationality Act of 1981. The passport office, however, wrote to him to demand that he carried out a DNA test to prove that he is the biological father of the baby Said. Um, Mustafa says, no, I'm not comfortable, and wants legal advice. So let's advise Mustafa. I've given you three options. As the passport office has demanded DNA to prove he is the father of Said, he has no option but to go ahead with the DNA and provide the evidence. Another one is DNA is the only way that he is to prove that he is the father of Said. Therefore, if he does not provide it, his son's passport application will be rejected. Or are you going to tell my friend Mustafa that, listen, DNA is voluntary, therefore you can choose to provide it or not? Think about this. But let me also run you through my social media platforms. And when I come back, I'll pick up your answers. And then we'll run it by our resource person and guest, Lawyer Charles Asma, to see which advice will be the best and the most appropriate for Mustafa. Welcome back and thank you for sticking around. We're live on BW TV and the program is The Community and the Law, brought to you by BWF Solicitors. So what are your answers? Let's see how quick, smart, and of course attentive you have been. First one from Grace of Dame, and Grace is saying, as the passport office has demanded DNA to prove he is the father of Said, he has no option but to go ahead with it. NS Kakari also thinks same, that once it's been demanded, he must provide. Kwame Jabba says DNA is voluntary, therefore he can choose to provide it or not. Okay. Um, Michael Abeye thinks it's number three as well. Thank you, Michael. The next one is from Wendy Dia. DNA is the only way to prove that he is the father of Said. That is number two. Therefore, if he does not provide it, his son's passport application will be rejected. Nanajo Pedro also comes in with an answer that is number three. Thank you, Najwa. The next one is from Kwabna Jemfi. Kwabna Jemfi thinks it's number two, as we see on the screen. Elizabeth Jadu Lizzie says it's number three, as we see on the screen. The next one is from Jacob Abwaji. He thinks it's number one, as we see on the screen. Next is Michelle Drew. DNA is voluntary, so he does not have to provide it if he chooses not to. Mami Grace thinks it's number three. DNA is voluntary. And for Sia, DNA is voluntary. Esther Wusu, DNA is voluntary. Tiliduma says DNA is the only way to prove, that's number two, that he is the father of Said. Therefore, if he does not provide it, his son's passport application will be rejected. Kwesi Jima thinks it's number two as well. Thank you, Kwesi. Next is Yapia. Yapia also thinks it's number two. And then Jennifer Pepper says it's number three. Let's see what the correct answer would be. Laya, one, two,
Yes.
or three.
Right. So if we look at point one, it says that passport office has demanded it, so you have no option. That is emotional, isn't it? That's what I mean. Yes, they said do it, so do it. No, but is that what the law says? Okay. Go to B. Since that is the only way to get what you want, like a blackmail. That is the only way to get you want, to do it. But you don't have to do it if that is not what the law says. 3, volunteer if you want to. That is what the law says. So he can choose to volunteer if he wants to, but he cannot be forced to. The answer is 3.
Well, the answer is 3. DNA is voluntary, therefore Mustafa cannot be forced to provide it. He can rely on the child's birth certificate as proof of paternity. Now, remember earlier on, lawyer mentioned that if the person married to the mother at the time of birth could be seen as the legal father of the child. You know, if you want examples and pieces of information that will enhance your knowledge and also embolden you, you do not have to miss nuggets, and also you do not have to miss the community and the law ever, which comes away every Saturday afternoon between 4 and 6 p.m. Late but not late is what we discussed this afternoon, the human phase of the immigration application and appeal rules. What did we say? Lawyer Asma from BWF Solicitors will give us the summary.
Right. So late but not late. All we are saying is that if you have missed the deadline to make your application for extension of your visa or to switch your visa, or you had 60 days and you have missed it, you have 14 days after the deadline date to still make the application under paragraph 39E of the immigration rules. The only thing you are going to lose is that if you were protected under Section 3C about work, about rent, and all those things, because you have become an overstayer after the deadline, even if you put in your application, those restrictions can follow. But you can apply because there's human face to the rules. Again, you have to show that there is a good reason why you could not apply in time or before your visa expired. The same applies to appeals. The same applies to administrative reviews. And the same applies to judicial reviews. If you are bringing appeal or administrative review or judicial review and you are late, because it's a civil procedure matter, CPR 3.9 will be activated, which says that in making such late applications, you have to include reason why you are late. And if the reason is accepted, the Home Office must accept your application for the admin review request. Again, court will consider your judicial review application once you add the reason why you are late. And again, court will accept your appeal request if you are late and you have added your good reason for lateness supported by evidence. There is human face to every law, including immigration rules in the UK. Late, but not late. Still go ahead and attempt the application under the rules.
If we were in an auditorium, I would say a round of applause for Lawyer Charles Asma and a round of applause for BWF Solicitors for giving us this wonderful opportunity to come your way every Saturday afternoon between 4 and 6 p.m. for the program The Community and the Law, as we have done this afternoon. Asma, thank you very much. BWF Solicitors, we doff our hats to you. Thank you so very much for giving us this opportunity, and we urge people to visit you and make use of your services. Call them on 0208 493 7340 and or visit them on the 4th floor of the Anna House, 214-218 Tottenham High Road. It's been another wonderful edition of The Community and the Law, and we want to invite you to join us again same time next week for another edition, which may be the one ending in 2025. My producer has been Professor Ade, and supported and produced together by Sheila Ankra and Padmo Tutu. My name is Ulrico Frippon. Good evening and enjoy Christmas when it comes.